Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, hearsay, exceptions, and privileges. Let's begin. Hearsay is the most tested evidence topic because it forces you to ask why a statement matters. A statement is not hearsay merely because it was said outside court. It is hearsay only if offered to prove the truth of what it asserts. If the relevance lies in the fact the words were spoken, the listener's reaction, legal effect, notice, knowledge, motive, or verbal conduct, the statement is not hearsay. Privileges are different. They exclude reliable and relevant evidence to protect relationships and policies. California privileges are statutory and are especially important on essays. A hearsay exception cannot defeat a privilege. If a valid privilege applies and is not waived, the evidence is excluded. Hearsay, an out-of-court statement offered to prove the truth of the matter asserted. A statement includes oral or written assertions and nonverbal conduct intended as an assertion. Non-hearsay purposes, verbal acts, legally operative words, effect on listener, notice, knowledge, motive, state of mind circumstantially inferred, impeachment, and words giving context are not hearsay. Federal exclusions from hearsay. A declarant witness's prior inconsistent statement given under oath at a proceeding or deposition, prior consistent statement offered to rebut fabrication or rehabilitate on specified grounds, and prior identification after perceiving the person are not hearsay if the declarant testifies and is subject to cross. Opposing party statements are also not hearsay, including adoptive statements, authorized statements, agent or employee statements within scope during the relationship, and co-conspirator statements during and in furtherance of the conspiracy. Unavailability exceptions. Former testimony. Prior testimony is admissible if the declarant is unavailable and the party against whom it is offered, or a predecessor in interest in a civil case, had an opportunity and similar motive to examine. Dying declaration. In homicide prosecutions and civil cases under the FRE, a statement made while believing death imminent about cause or circumstances of death is admissible. California permits dying declarations in broader civil and criminal contexts under its statute. Statement against interest. An unavailable declarant's statement against pecuniary, proprietary, civil, or penal interest when made is admissible. Penal interest statements offered in criminal cases need corroboration under the FRE. Forfeiture by wrongdoing. A party who wrongfully caused the declarant's unavailability intending that result forfeits hearsay and confrontation objections. Declarant availability immaterial. Present sense impression. Statement describing or explaining an event while or immediately after perceiving it. Excited utterance. Statement relating to a startling event made while under stress of excitement. Then existing state of mind. Statement of current intent, motive, emotion, plan, or physical condition. Usually not a statement of memory or belief to prove the remembered fact. Medical diagnosis or treatment. Statement made for and reasonably pertinent to diagnosis or treatment, describing medical history, symptoms, cause, or source when relevant to treatment. Recorded recollection. A record made or adopted when fresh in memory, accurately reflecting knowledge, used when the witness cannot recall well enough. Read into evidence, received as exhibit only if offered by adverse party. Business records. Records of acts, events, conditions, opinions, or diagnoses made at or near the time by someone with knowledge, kept in regular course, as a regular practice, shown by custodian certification or testimony, unless untrustworthy. Public records. Records of office activities, matters observed under legal duty and in civil cases or against the government in criminal cases, factual findings from legally authorized investigations, unless untrustworthy. California hearsay labels. California has many similar exceptions, but different names and details. California recognizes party admissions as hearsay exceptions, not federal-style exclusions. The result is often the same, but the terminology differs. Prior statements. California Evidence Code Section 1235 allows prior inconsistent statements as substantive evidence if the witness is given an opportunity to explain or deny. Section 1236 allows prior consistent statements when offered after an inconsistent statement or charge of recent fabrication and made before the alleged motive to fabricate. Section 1238 covers prior identifications. Spontaneous statement. California's spontaneous statement exception resembles excited utterance. California also has a contemporaneous statement exception similar to present sense impression, but not always identical. Declarations against interest. California requires the statement be so far contrary to declarant's interest that a reasonable person would not have made it unless true. Penal statements are treated carefully. Privileges. California privileges include lawyer-client, physician-patient, psychotherapist-patient, clergy-penitent, spousal privileges, official information, identity of informer, and others. Privileges belong to the holder. Waiver generally occurs by voluntary disclosure of a significant part of the privileged communication or consent to disclosure. Spousal privileges. Under federal common law, an adverse spousal testimony privilege in criminal cases generally belongs to the witness spouse, and confidential marital communications are protected. California has both a spousal testimonial privilege and a confidential marital communications privilege, governed by statute, with exceptions for crimes against the spouse, children, or household, and certain proceedings. Attorney-client protects confidential communications between client and lawyer for legal advice. It does not protect underlying facts, future crime or fraud communications, disputes between lawyer and client, or communications relevant to breach of duty. Confrontation. In criminal cases, testimonial hearsay against the accused is inadmissible unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine. Testimonial statements include formal police interrogation aimed at proving past facts for prosecution. Ongoing emergency statements are usually non-testimonial. A machine-generated result is usually not a statement by a person, but human assertions in reports can be hearsay. Police reports in criminal cases are frequently barred when offered by the prosecution, especially if testimonial. Business records do not admit every statement inside the record. Each layer of hearsay needs its own exception. Statements to doctors about fault are usually inadmissible unless pertinent to treatment, such as domestic abuse identity in some contexts. State-of-mind statements prove current intent, not remembered facts. I plan to go to Sacramento can prove later conduct. I remember Dan hit me usually cannot prove Dan hit me. Privilege can be waived. Confidentiality is essential. Presence of unnecessary third parties often destroys privilege. Use a 3-step hearsay script. First, identify the statement. Second, state the purpose. Third, if hearsay, find an exclusion or exception and address confrontation if criminal and testimonial. On California essays, add the California Evidence Code label and privilege statute concept. For privileges, write confidential communication, protected relationship, holder, no waiver, no exception. Then apply facts. If a client brings a friend to the meeting for comfort, ask whether the friend was necessary to facilitate legal advice. If not, confidentiality may be lost. Note: hearsay is not about whether the statement is trustworthy in ordinary life. It is about whether the legal system has a recognized substitute for cross-examination. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.